Nick's going to do most of the speaking because I gave him the historical reappraisal part of the presentation. So thanks for having us talk today. I think we've already learned a bit from our project from the previous two speakers, so it's a good conference when that happens. So, sorry, skipping my slides. So this is a very new project for the two of us. So we're combining Nick's legal history approach and my corporations and institutionalist approach. And really, we're looking at why is equity the foundation for accountability in corporations law in many of our jurisdictions. So we're asking, why is that the case? We'll critically analyze the historical origins of the director accountability in the courts of Chancery in England and the cases that followed there. This generally conceived of the corporation as a private relationship between and the courts were looking for a remedy where none previously existed. And I think that's come out in some of the previous presentations as well. We think that the corporations, at least some of them, have since adopted more public elements or public institution elements that make us question why we still so heavily rely on equity. Okay, I think that's all that I have to say. Now, this is still me. So we're looking at classifying the corporations throughout history, which is a big task, obviously. There's some origins in the idea of partnership. So the corporation evolving from partnership particularly in the city-states of Italy. Then you move to the corporation as a form of internal administration when you're looking at ecclesiastical bodies, boroughs, and guilds. And then the corporation that we're probably more familiar with today, in some respects, is a proxy for the achievement of public goals, however you so characterize those public goals. And these are the companies that everyone is probably familiar with: chartered companies, joint stock. Everyone probably talks about the Bubble Act at some point when they're teaching corporations law and the ramifications of the Bubble Act and the deed of settlement companies. And this is where our story kind of starts in the historical analysis, and where Nick will start to talk about Sudden again.
Yes, I thought the chances of no one else mentioning Sudden are quite slim, so I'll sort of delve into it a little bit more. I think one way of conceiving the project is sort of a historical exploration of this public-private tension in contemporary corporations law against the corporate landscape or against the background of the corporate landscape that Steve briefly sketched out. I wanted to sort of hone in a bit more on the foundational decision of the English Court of Chancery in 1742 in the charitable corporation in Sudden that has already been briefly mentioned. It's one of those foundational landmark cases in the Anglo-American common law tradition that's often referred to briefly, but seldom explored in much depth in legal historical work unrelated to corporations law. I've taken an interest in some of these so-called foundational cases and tried to give them a more rigorous treatment. So I thought I'd give a go of doing the same with charitable corporation and Sutton. We know a little bit about it just from a very brief perusal of the historical sources. It was like other early modern English companies that have already been mentioned, incorporated by a charter of Queen Anne in December 1707. Its object was to raise stock for the distinctly charitable purpose of lending money to the deserving poor on pledge or pawn of their goods. We know that the management of the charitable corporation's affairs was vested in a committee consisting of some 7 persons who were originally appointed under the Royal Charter. Among those 7 so-called committee men, or as we would more familiarly know them now, directors, was the prominent English Whig parliamentarian and financier Sir Robert Sutton, who was the first named defendant in the action that ultimately came before the Court of Chancery. The dispute between the corporation itself and Sutton, and indeed many others, arose from a fraud that some 5 officers of the company had perpetrated against it. The fraud was of a twofold nature. These officers, some of them had lent more sums of money upon old pledges without calling in the first sums lent. And secondly, and relatedly, these same officers had lent money to themselves upon entirely fictitious pledges. The effect was to occasion loss to the charitable corporation in the astronomical sum of some £350,000. In a nutshell, the corporation, at the instigation of its shareholders and following considerable public consternation, brought an action against not only Sutton, but some 50 other officers of the company seeking to have that loss made good. In other words, seeking to have those involved at the higher ranks of the company made accountable for it. It's no surprise that the plaintiff corporation decided to bring its action in the Court of Chancery. We know that the Court of Chancery, as opposed to the courts of common law, had been well suited to the enforcement of early trusts or uses. And it appears that the procedure of the Court of Chancery in particular was perceived to be at the time, that is to say in the mid-18th century, also well suited to the enforcement of the duties, I should say rather, of directors. A few aspects of Chancery procedure I think are worth mentioning. First, the Chancery, as opposed to the common law courts, was not tied to a rigid scheme of actions or remedies sounding exclusively in damages and to be assessed by juries. Instead, it could mould relief to do what was just and equitable before the parties, before the Lord Chancellor. The Lord Chancellor could also summon the parties to the dispute before him and examine them personally. And finally, the Chancellor, again, as opposed to the common law courts, had a considerable staff of clerks who were capable of conducting complex accounts. Particular of interest, of course, is Lord Hardwicke's speech in the charitable corporation in Sutton. The action was heard before Lord Hardwicke in Lincoln's Inn Hall in August 1742. And really the key issue for determination before the Lord Chancellor was who among the corporate officers of the charitable corporation could be held accountable for the loss that had been occasioned to it by the fraudulent conduct of some 5 of its officers. Counsel for the charitable corporation's central contention was that in addition to the 5 actual fraudsters, all 7 of the company's committee men or directors could also be held liable, equitably liable, to account for the loss that the company had suffered, albeit in the 2nd degree. And it's that explains why Lord Hardwicke, I think, spent quite a considerable amount of time in his speech examining the nature of the directorial office. As Susan has already pointed out, it was, at least to his mind, in the nature of a mixed office, mixed in the sense of comprising both a public and a private aspect. He's reported to have said in Lincoln's Inn Hall, the office is partly in the nature of a public office and partly as a private office in trust for other people. As far as Lord Hardwicke was concerned, its public nature derived from 2 main bases. First, I've lost myself here. Yes, its public nature derived from 2 main bases. First, the particular office under examination was originally founded under a royal charter. That in and of itself gave it some public aspect. Secondly, any mischief, and relatedly, any mischief on the part of those holding such a office would tend to affect the public credit. From my reading of the 2 extant reports of Sutton, however, Lord Hardwicke seemed to take the view that despite that public aspect of the directorial office, it was overshadowed or overborne by a more rigorous private aspect. And this is what he went on to say, speaking to the extracts that I have on the current slide. The directorial office does not concern public government, but rather the negotiation of private property. It is therefore a private office, like the directors of the Bank of England, the South Sea Company, and other trading companies, where they are not obliged to qualify by taking the sacrament and oaths as for a public office. Now, that's not to say that they didn't take any oaths, which Susan has already pointed out, but they did not have to take the equivalent oath of someone who was assuming a public office, but are only entrusted with property of the aggregate body, that is to say, its shareholders. And as that final part that I've just read out, and that's excerpted on the current slide, I think quite clearly shows the closest, as far as Lord Hardwicke was concerned, the closest and most compelling analogy between the directorial office, at least insofar as royally chartered companies were concerned, And sorry, the private aspect of the directorial office was that of trustee of property held on trust for others. The basis of that analogy seemed to lie in the fact that, like trustees, directors were similarly entrusted with property that was to be held and managed for the benefit of others. That was despite the fact, importantly, that unlike trustees who have legal title to the beneficiary's property, directors did not themselves have legal title to the monies of the corporation's shareholders. So they're not trustees stricto sensu, but the analogy was nonetheless compelling enough for Lord Hardwicke. We already know that Chancery had been identified as the right civil venue in which to enforce trusts, and therefore the analogy is hardly surprising. So what's the significance of Sudden ultimately? It seems that by the middle of the 18th century, we do have a Royal English Court in the form of the Court of Chancery conceiving the directorial office in a case involving a dispute between a company and, or at least the shareholders of the company and senior officers within it in essentially private terms. Not only in essentially private terms, but via a specific analogy with the long existing office of trustee. So a comparison between the corporate office and the existing office of trustee. And it was that essentially private conception of directorial accountability that would in turn direct and further inform English law's regulation of the institutional corporate landscape that Steve began sketching out at the very start, well into the 19th century, and despite landmark statutory reforms that do appear in the middle of that later century, particularly the Consolidating Joint Stock Companies Act of 1856. Steve, do you want to just round us off?
Yes. So following on from that, what we're really asking is whether this origin of accountability for directors is still suitable to form the foundation or the center of how we hold directors accountable for all forms of corporation, really. And so I'm going back here to Abram Shayers in the Modern Corporation and the Rule of Law. If we seek to reorganize the structure of the corporation to assure more responsible exercise of power, what would be the starting point? What's the institutional structure of the modern corporation? And the question that we had was, would you start by saying, we'll hold them directors mainly accountable through good faith to the best interests of the company? Is that what you would do? Would you go to equity? Can we continue to justify such heavy reliance on these concepts developed in the courts of chancery at this time? So that's what we want to explore more in this project, see exactly what the cases and what the court said following this case and how the law evolved. And of course, you can not really have a corporations conference without mentioning Burleigh and Means at some point. And so in their work, they think they characterize or provide three forms of accountability. The first is characterizing it as a relationship of trust, which is what we were talking about in Sudden, for instance. Or given the contractual nature of the power structure, free rein to those with power, the controllers, limited only by contract law. And then they set out a third or another option there, they've placed the community in a position to demand that the modern corporation serve not alone the owners or the control, but all society. So they're talking more, and other authors at the time, commentators at the time, were talking more of the corporation adopting a bureaucratic kind of role within society, and therefore we need to consider potentially that type of accountability regime for certain forms of corporation at least. And going back to Shayers here, conceiving of a more spacious conception of membership, which is more accurate to the corporate life, modern corporate life. It would include all those having a relation of sufficient intimacy with the corporation. Here he really minimizes the role of the shareholder or the significance of the shareholder in terms of an accountability mechanism for some types of corporation. And that's what we're going to explore a little bit more in our project. That's it.